Welcome to Military Justice and the law presented to you by Bulelani Tsewu. In this episode, I'll be talking about the removal of a military judge from office. Section 17 of the MDSMA authorizes the Minister of Defense and Military Veterans, the Minister, to remove a sitting military judge based on the advice given by the Adjutant General. However, the MDSMA is silent on the procedure to remove a sitting military judge. It simply says that such a judge may be removed based on misconduct, if he suffers from incapacity, or is incompetent. So basically, those are the grounds that are prescribed in the legislation. It is this gap or lacuna that resulted in a stalemate in Minister of Defense and others versus O'Brien and others. Because in O'Brien case, O'Brien had made certain court orders wherein he ordered the President of the Republic of South Africa to investigate the Minister of Defense and Military Veterans, because the minister had failed to assign military judges over the period 2015 to 2016. So obviously, or it goes without saying basically that the hierarchy within the military were displeased by the orders that were made by Colonel O'Brien, who was a military judge in that particular trial. So what then happened after that was that the Adjutant General at the time convened a board of inquiry to basically look into the conduct of Colonel O'Brien as a judge, because he had made certain exclamations regarding the security of tenure of military judges. Although O'Brien objected to the process, it started. So, within the context of the South African National Defence Force, a Board of Inquiry, a BOI, is an administrative procedure to inquire into any matter concerning the SNDF. It could be in relation to the loss of property, or maybe the member has disappeared from work for a period of 30 days, so usually it gets convened. And the person who is empowered to convene a Board of Inquiry includes the Chief of the South African National Defence Force, the heads of divisions and services, officers commanding, together with their delegates. In a Board of Inquiry, importantly, witnesses testify under oath. However, sworn statements may be admitted if an affected person does not object. It is usually composed of 3 members, basically. You'll find that as an officer who typically must serve as the president, and 2 other members, a member and a secretary. But that is not cast in stone, could be fewer members. That depends on the convening authority as to how many members does he or she wants to basically participate in the Board of Inquiry. Key to this is that the findings or the recommendations of the Board of Inquiry are not binding on the convening authority. By that I mean the convening authority has a choice to either reject or approve the recommendations. So essentially, a BOI is seen as some sort of evidence that can be considered together with any other information that is at the disposal of the convening authority. So basically, with that a BOI, there is always a risk that the convening authority may convene a BOI with a predetermined outcome. But I'll return to this in due course. So This BOI that was convened against Ken O'Brien was subjected as well to the process of review by the High Court, whether indeed it can be used to inquire into the affairs committed by a military judge while sitting in his capacity as a military judge. The High Court in Minister of Defense, this O'Brien case, concluded that a BOI may be used as a proper vehicle to remove a sitting military judge. Look, I was shocked at the decision myself, and O'Brien appealed it. However, the lawyers of the Minister of Defense on appeal before the Supreme Court of Appeal expressed reservations as to the appropriateness of the Board of Inquiry to remove a sitting military judge. Thus, there was no longer now an issue because they were not disputing the issue. In fact, they were in agreement with the appellant that a BOI is inappropriate in terms of being used to remove or to investigate the sitting military judge. The Supreme Court of Appeal stated that, look, the matter is therefore moot. There is no need for it to basically pronounce on the issue because there's no longer a live dispute or live controversy between the litigants before the court. This is where I have a problem with the decision of the Supreme Court of Appeal in that regard, because as things stand now, we know that court orders must be obeyed. On that score, the order or the decision of the High Court says that a BOI may be utilized to remove a sitting military judge. So, the Supreme Court of Appeal did not set that decision aside. Therefore, that decision remains in force and is valid. So this is where there is a problem, because it has created some sort of a legal certainty. Courts ordinarily deal with concrete disputes. If there is no concrete dispute, the court need not bother itself by embarking on adjudicating on matters, that are hypothetical in nature. That is understood, that is right. However, there is an exception to the doctrine of mootness. And that if the court, looking at the matter, can say that it will be in the interest of justice to adjudicate it, despite it being moot as between the parties, the court can entertain that particular matter. There is authorities abound where the Constitutional Court has affirmed the principle that if it is in the interest of justice, then the court can basically entertain it. Or if the matter basically raises, an issue of public importance, a discrete legal question that would benefit the public at large, the court can entertain a matter that will otherwise be moot. That's the principle. So for me, for the court to fail to do that, it deprived us all of the opportunity to see what will the court's position be had it considered various constitutional principles that I believe are relevant here. For example, judicial independence, which basically implicates the right to fair trial and other things like separation of powers. Because one must understand that the Adjutant General, when he convenes a board of inquiry to investigate a sitting military judge, he acts in his capacity as a member of the executive. So now you have a situation where the executive is empowered to basically investigate and discipline a military judge without an independent inquiry. That cannot be a constitutional outcome. Now, flip the coin. The judges of the High Court, Supreme Court of Appeal, Constitutional Court, all those people get removed from office pursuant a stringent process conducted by the Judicial Services Commission. Magistrates on their side, the process is conducted by the Magistrates Commission. Parliament is involved because Parliament must vote 2/3 majority, must say a judge is not fit for office. Then the president must basically remove the judge. With magistrates, if ever the resolution is adopted in Parliament, that the magistrate be removed. The Minister of Justice and Constitutional Development must remove that magistrate. These processes are very stringent, but yet the processes to remove a military judge are basically left at the mercy of the executive. That cannot be right. That cannot be right. So essentially, there is still legal uncertainty regarding what needs to happen to remove a sitting military judge. I would suggest that a process similar to that apply to the removal of civil judicial officers ought to apply. And that committee can be composed of retired military members and lawyers. In that way, it will basically guarantee its independence. I trust that you enjoyed this episode, and whoever has not subscribed, please subscribe. In the next episode, I will be basically discussing the Directorate of Military Judicial Reviews and whether that directorate, the existence thereof, is consistent with the Constitution, primarily Section 35(3)(0) of the Constitution. Until next time, take care.